Chad, can you hear me? West conference room.
Yeah, maybe a little bit. You're not very loud. I'm gonna adjust some settings and then I'll have you talk again.
All right.
Okay, go ahead. Try again.
West conference room. West conference room. Test, test, test. West conference room. West conference room. Test, test, test.
I can hear you better now.
You can hear me well now?
Yeah. This is smart.
Test, test,
You're not sitting in for anybody.
Yeah, I'm sitting in for Jim and Joel.
Oh, you are? Oh, that's right.
Yeah. So we as executive.
Crap.
This is the last one, though, because I pointed it out.
Oh, yeah, just now. Sure. Yeah, okay. I'm just thinking all we're missing is Brad. So we could have a quick right there.
Go ahead and try again.
test, test, test. West, west, west. Can you hear me? Can you hear me?
Yeah, we can hear you. What you may want to do is maybe have them move closer to the TV for or when they speak. So probably to the front of that table
All
or
right.
up to the table. That'll help.
Right here. Right here.
Yeah, that sounds good.
All right.
Members that are joining the meeting, please mute your mic. We do not want to have disturbing sounds coming in from your end. If you do want to speak, you can unmute. Public comment. Otherwise, verify that you are muted. If you are calling in, it's *6. If you are coming in through a computer, it should be a little icon. It looks like a microphone with a line through it. Please verify you are muted. Otherwise, we will mute you. And if you do want to do public comment, you may not be able to unmute.
Okay, Brad was going to try to get on too. I was going to try to get on there.
Get you where you want.
You say that I'm sitting here and then is there a place that I would tell you guys that agenda? That there will be someone here next month?
Maybe we'll do right in front.
When you call the meeting to order.
Call the meeting to order. Let's do it right there. To explain it, that you're sitting in for Jim Angel. And that someone's been appointed, it just has to be approved at the next board meeting. Maybe that's, I'll just ask. Well, no, we'll just do it. I get screamed at, yeah.
So just remember to keep your microphone.
Sure. All right, so technically we're ready. Technically we're ready. Okay, that's what we need. We'll call the meeting to order. I'm gonna have Mr. Nelson explain why he is here. And he's actually sitting in for Mr. Jim Agile.
Yeah, again, committee members, through our executive committee, in the passing of Jim Edgell at executive, we've asked supervisors to sit in for Jim Edgell on all his committees. I was chosen to do the environmental services. This will be my last meeting to sit in for him. At the next county board meeting, Sharon Kelly will be up for confirmation for Jim's seat and to finish out his term, and she will be sitting on the committee in the future for Jim.
All right, thank you. Number 2, approval of the agenda. From Tracy, is there a second? Second from Doug. All those in favor say aye. Opposed? Okay. Number 3, approval of the minutes of the June 10th meeting. Okay, Doug. Seconded from Tracy. Anybody see any corrections or anything? If not, all those in favor say aye. Opposed, the same. Public comment, we're gonna try to hold that for 30 minutes or less. I think are we doing public comment? Only the participants in the West Conference room. All right, so we will ask the West Conference room, is anybody there for public comment?
Does anyone here want to make public comment? We have one, Mr. Chairman.
All right, have him state his name and stuff and then give us his comments.
Okay, all right. Hi, I'm Mary Curran from the town of Eureka, and I was looking at the agenda and I was a little confused because on number 5 there was something to the effect of disclosing conflicts of interest with some of the people that were present on that committee and so forth. And that seems to be eliminated. And now instead, we seem to have some corporate lawyer up to talk from Madison, with whom apparently a couple of the people from Polk County Board have hobnobbed with down in Madison. And I'm curious as to why we have eliminated this conflict of interest business. So it seems like democracy is sort of being whittled away here. People aren't being able to comment as they would be able to, partly because of this virus business. But I'm concerned. I'm concerned that things get kind of rolled over and don't really get addressed, and people don't get a chance to really get in there and comment. Thank you.
Thank you. Anyone else?
Anyone else? Mr. Chairman, that's all from the web.
All right, thank you. All right, with only one public comment, we will then move to number 5. We do have a presentation. This is from the Wisconsin County Association, not a private lawyer.
Hello.
Hello.
Good to be with you. I'm Dan Barr from Wisconsin County Association. With Polk.
Okay. Is this better? That's a little bit better. Okay. Okay. Well, good morning, everybody. Good to be with you. And I'm Dan Barr from the Wisconsin Counties Association, and I'm a registered lobbyist for the association. And my primary issues are ag, environment, land use, transportation. We lobby for funding. We lobby on policies. And I know we're here to talk about zoning and CAFOs and CUPs, which we will get into. Ultimately, from a policy standpoint, as it relates to zoning, because I do try to get your road funds and things like that out of the state legislature, out of the federal government. But in terms of zoning, one of our primary goals is to ensure that you keep all your tools in the toolbox. The powers that the county has on zoning are derived from the state. Counties, we're a subset of the state, so we have to get authority from the state to conduct our zoning, the powers that we have, and of course that is limited. And my goal is to get you as much of it as you can have, so that you have the tools in the toolbox, and so that you can keep it, of course. And so that's part of the discussion we'll have as we move forward. But that's essentially my role, is to be your voice and your representative in Madison on behalf of all 72 counties. All 72 counties are members of the Wisconsin Counties Association. And so for that reason, we try to represent you to the best of our ability. And of course, as a representative, as your representative before the state legislature, I'll give you a political view on zoning and some of the issues that have been brought up in the state capitol, and some of the different perspectives. Of course, there are many different perspectives, but want you just to be aware of how things are viewed. But a little bit of background, and I'm going to I understand this is a pretty senior committee. You got a lot of people with experience in terms of land use and zoning, so I was going to do sort of a general information on zoning, but I can kind of move through that very quickly. We can get to the CUPs, and then I understand you have discussions and comments and questions, and so we'll try to get to that. We'll do more of that than we will on the zoning 101 portion of this. But just going through general information, type of decisions, zoning amendments, rezones, variances, okay? Conditional use permits, CUPs, as they're known as, which is your main interest here. We'll try and get to that, but that was the overview. We'll go through general information, go to the next slide. So the zoning authority, like I said, zoning authority, we derive our authority from the state. Wisconsin Statute Chapter 59 is where we get our authority. The state has to give it to us. We can't just do it. The state has to, we can't do things that the state does not allow for or we don't have power to do. And if we do those things, then we're vulnerable to lawsuits, and it can cost the county money, and the decision can be nullified. So there's that. We have a home rule statute in that chapter. As I said, that's how we get our authority. But limited by state statute is our authority. Counties are governed by the Board of Supervisors, and I think all committee members are members of your Polk County Board of Supervisors. That's correct? Okay. And there's a series of statutes that relate to your zoning, your planning and zoning authority. Wisconsin Statute 59.69, zoning authority and the adjustment board, your Board of Adjustment, or your plan commission. Depends what the county would choose to call it. There are statutes related to open meetings law to ensure that everything you do in the county from a public standpoint is open and transparent to the public. Public records law, ethics requirements, quorum, that deals with quorum and sort of your functions, your ethics requirements, things like that. Case law as well. Courts review various zoning cases, and once a decision is made by those courts, that sets a precedent. And that's sort of your case law, and so we respect case law. That's not necessarily law, but we do respect case law. So until the legislature comes and weighs in with actual statutes, we defer to case law. Lawyers will, your court counsel, is Malia here? There she is. Hey, Malia. So your case law is something that she'll probably oftentimes reference when she discusses things with you. And your resources as it relates to zoning is your comprehensive plan, which is sort of your long-term vision for how you want to grow in the county. Your zoning ordinances, which are the ordinances that dictate what the zoning use may be. Planning commission bylaws, those are your bylaws by which your planning commission, your Board of Adjustment operates by. Regional planning commissions, and also your local planner, your staff and other professionals, Vince and Malia in the back and other staff that are here. So things to know. County structure and zoning, and these are different statutes. I won't get into this too much because I don't want to get too much in the weeds. And I know we want to get to the CUPs as soon as possible, so we can kind of skip through some of this. The roles of a plan commission, I think you guys have a Board of Adjustment, not a plan commission. Same difference, essentially. But the community planning, you prepare and recommend a comprehensive plan. A lot of times counties typically update or rewrite their comp plan every 10 years. I don't know if you do that here every 10 years. Is that pretty much the standard across the state? Typically 10 years is a standard for rewriting a comprehensive plan. Public participation, public meetings and hearings, implementation, prepare and recommend ordinances and amendments. A lot of times that's done off the comprehensive plan. And decision making can be quasi-judicial, legislative, your county board, And there are also administrative decisions that are made. We can talk about some of those things too. But that's sort of some of the background on zoning. But type of zoning decisions, and we'll move through this very quickly too. Your legislative, at your full county board would make a decision. Quasi-judicial would be one of the committees. Administrative would be administrative work based on the statutes, the ordinances, things like that, state statutes and your local ordinances. But your legislative decisions are policy making. Your county board, they set the policy, of course. Those are decisions that affect the community as a whole rather than a small area or fewer individuals. And I won't get into it. I think you guys understand the role of the county board and things like that. And so I wanted to kind of move past the legislative. And you're all on the county board, so you understand that, I think. And I know you want to get to the CUPs. But quasi-judicial decisions do involve the application of rules, the facts of a particular proposal or application. They involve the exercise of some discretion, but not too much, because again, the ordinances are the ordinances. But where there's discretion, sometimes you get into a quasi-judicial situation. But quasi-judicial decision makers must apply the law as written, whether it be state statutes, not really afforded the ability to substitute their judgment in place of the written statutes. But there is some discretion, even with statutes, obviously, decisions have to be made. Rules of due process apply in quasi-judicial decision-making. Examples of quasi-judicial decisions may be granting of a conditional use permit, a CUP. So where, let's say the statutes does not require an approval based on conditions being met, it'd be a quasi-judicial decision. Subdivision plans, variances, some circumstances, individual property rezoning could be treated as a quasi-judicial decision. And then administrative decisions involve the routine application of rules. Discretion is limited to routine nature of decisions, the implementation of the zoning codes in place, but obviously the zoning administrator has some discretion as he or she would apply it. And there's some examples there. The issuance of a sign permit or a building permit is an administrative decision. Of course, that'd be based on the code as written, but the administration of such would be done by staff. So then we'll get into more, something more that you're probably interested in, and I'll finish this presentation, but I want to give you some background on zoning from a larger view. We'll get into the zoning. I guess we can, okay. So zoning ordinances is made up of both the zoning map and the ordinance text, two types of amendments that take place. In terms of zoning, there's a reason. We might have to go back. I think I'm missing some of this information here. We can skip. We can go forward because I think for the purpose of this presentation, you would like to talk about the CUPs. I won't get into. What's that? Did you guys want information on the variances, or do you kind of have that information? You feel good about that? You okay? Okay. Well, we can skip it, and that's no problem. Okay. So let's go into CUPs, just to get into a little of the background on how CUPs work. So we'll go to the next slide. The definition of a conditional use is a use allowed under a conditional use permit, a special exception, or special zoning permission, but does not include a variance, okay? So in other words, obviously a conditional use is, I have a piece of property, and let's say on my property, I don't necessarily meet the zoning code, but you're going to give me an exception based on a condition that I meet. That's a conditional use. Obviously there's a condition, and I can do the use. Conditional use permit, and you go back to Wisconsin Act 67. Essentially, there was case law involving conditional use permits, and that case law. Then I wanted to mention Act 67 because your former state representative Adam Jocko was involved in writing it, and essentially they codified the previous case laws, and so we do have written statutes now on conditional use permits in the form of 2017 Act 67. Okay. Act 67 codifies local government responsibility for setting conditions. Ordinance requirements and conditions must be reasonable and to the extent practical and measurable. Must support decision to approve or deny a permit, with evidence and actual statute and conditions, things like that. Conditions must relate to the ordinance purposes. So when you think about a CUP, if you're going to grant a CUP and you have a condition, the condition must relate to the goal of the ordinance. If the goal is clean water, if the goal is to protect the public health and welfare, then the condition must be put in place to protect the health and welfare and protect the water, for example. The condition cannot be unrelated to that, or should not be unrelated to that. The goal of the ordinance should mesh with the condition. And so I think that's very important to think about when you do issue a conditional use permit CUP, that they're sort of in alignment, the ordinance and the conditions associated with the CUP and the ordinance in general. Does that make sense to everybody? Now the basics, whether to include use as conditional in a zoning district is a legislative decision. That use is suitable for that district, okay? A zoning ordinance must list specific uses allowed in each district and decision criteria in deciding whether to grant a conditional use permit. If a conditional use is cited in the ordinance, the conditional use permit must be granted except when substantial evidence presented justifies denial, okay? So I think in Act 67, there's actually a term where it says it shall be approved if in fact certain conditions are met. And so again, that depends on your zoning code, but a lot of our zoning codes align with state law, and thus the word shall is used, added in Act 67. And so when you think about conditional use permits, those are things to think about. The deciding body should focus on what conditions to impose to mitigate negative impacts. Important things to remember. Denial and setting conditions. A conditional use permit may only be denied if denial is supported by substantial evidence. What is substantial evidence? Well, Act 67 spelled it out for us. Substantial evidence means facts and information other than merely personal preferences, speculation directly pertaining to the requirements and conditions an applicant must meet to obtain a conditional use permit, and that reasonable persons would accept in support of a conclusion. Still a little bit vague, and there is some discretion in that, I would say, but essentially, you have to make a decision whether the conditions have been met in terms of a conditional use permit. Setting conditions. Conditions must be reasonable and to the extent practical, measurable, and may include conditions such as the permit's duration, transfer, or renewal. Setting conditions, developing conditions. Specific conditions, standard conditions specific to each should be listed in the ordinance. Zoning staff may recommend conditions specific to a specific request and application. Conditions may be developed in response to comments in a public hearing. Now the key here is any condition imposed must be related to the purpose of the ordinance and be based on substantial evidence. So again, those conditional use permits, the key thing about them in order so that they not be challenged in court or be overturned, the condition by which the CUP, if you, for instance, and I'll mention this, let's say I own a strip of property and I want to do something in particular with it, but something is sort of unrelated to the goal of the ordinance, the condition that is required of me, it's not a valid condition. It's going to be overturned, likely going to be overturned in court or be challenged in court. And I think it's important to keep that in mind when you think about those conditions related to a CUP. Conditional use permits. What must an applicant demonstrate to be granted a conditional use permit? Got to demonstrate the application and all requirements and conditions established by the local government related to the conditional use permit are or shall be satisfied. Got to provide substantial evidence supporting the application and demonstrating that the requirements and the conditions will be met. If an applicant for a conditional use permit meets or agrees to all requirements and conditions specified in the ordinance or imposed by the deciding body, the conditional use permit must be granted. That's the law. So some examples of conditional use permits as it relates to CAFOs, because I know you're interested in CAFOs, and we'll get into questions and discussion and things like that. But counties often declare concentrated animal feeding operations, CAFOs, as conditional uses. If an applicant meets ordinance requirements, the county may set reasonable conditions based on substantial. This is a lens through which each condition must be analyzed. It is reasonably related to the intent of the ordinance and based on substantial evidence and not personal preference. Several other Wisconsin statutes and administrative code also apply to CAFOs. For instance, when you think about CAFOs, there's 5 permits that they are required to get, 4 through DATCAP, the Department of Agriculture, Trade, and Consumer Protection, 1 through DNR. The counties administer those permits, the permitting process, but the DNR then approves. And so there's sort of a checkbox that it goes through. But the zoning conditions, the zoning ordinances, the CUPs also derive through your governing structure through the county. Does that make sense, everybody? So it's a complex process to establish a concentrated animal feeding operation. You need to meet all the permitting requirements, which have been set by the state. Counties in the past, I'd say back before 2006, counties did have control of the permitting process, the approval of the permits. In 2006, NR 151 was, or sorry, not NR 151, DATCAP 151, that's the administrative rule overseeing the CAFOs and livestock siting. We had done that on our own. The state took the permitting process away. We administer the permits, but they ultimately approve, and they have the final decision over the permits. So be aware of that. Other examples of conditional uses that must also consider Wisconsin statutes and Wisconsin administrative code, wind farms, cell towers, adult-oriented establishments. Another one would be frac sand operation, silica sand. And so then we can open up for discussion, but I wanted to provide some background and some context and sort of a basis for your decision-making, your county board's decision-making, and just some food for thought in terms of all this. But I had a lot of information I had stuck in here and did some research, but I just wanted to sort of set the stage for your discussion. So we can open it up. I understand there's some questions and some hypothetical examples that some of you may want to bring up. So go ahead and bring those forward. We can have a discussion about those at this time.
All right, have you read our draft?
No, I have not. I have not read the draft. No, I've
Okay.
not read it yet, but you know what, I can do that. I can read your draft, but I understand it just came out recently, so I haven't not read it. No.
Yeah, okay. So we want to know the conditions, I think, what are legal and what aren't.
Okay.
So I think we did have, here's one of ours, that a farm operator owner must live within 5 miles of the farm.
Well, now, so I had heard about that condition. Someone
Okay.
had brought it up to me. And I would say this, as I mentioned before, the conditions in a CUP should be related to the goals set forth in the ordinance. Okay. Oh, sorry. Okay. Yeah, to answer your questions, the conditions in a CUP, a conditional use permit, should be related to the goals of the county ordinance. Okay. And so if your goal is protecting the public health and safety of the public, or clean air, clean water, whatever the goals are, you might derive that someone having the owner operator live within 5 miles, maybe you could make that conclusion, but I don't know if that's something that would hold up in court, because it's sort of, maybe the owner operator is within 5 miles and for that reason he takes more care and is more careful. Okay, but that's an assumption. That's not something that, you can demonstrate scientifically is going to happen. He still may be reckless in his operation of the facility. So I don't know if, again, I think the goal as elected officials, as you think about these things, you want to protect the taxpayer, you want to protect the county from getting sued. And so when you think about those things, to avoid lawsuits, maybe there's other conditions that might more further the goals set forth in the ordinance, other than having someone live within a certain distance of the facilities. But again, that's a policy decision. I'll tell you that. But and elected officials make policy decisions. But as a staff person, I would tell you that that's something that potentially could lead to litigation, which of course costs the county money, and ultimately could be nullified anyway. So all you're left with is, a situation where you have to pay a lawyer money to defend the county, and ordinance isn't in place anyway.
All right.
Yeah.
Go ahead, Doug.
We've had some discussion on performance bonds,
Okay.
and it seems like it's always in the siting side.
Mm-hmm.
What about on the operational side?
Okay.
I guess
So-
that would be the question is, why can't we put a performance bond on the operational side?
Well, so what would the goal of the performance bond be in terms of the operation of the facility?
Well, what the goal would be is to protect the public in the future. If let's say there's a large spill and they walk away.
Yeah,
I mean, is that explained correctly? That would be my way of looking at it. If there's a health outbreak because of the facility.
sure. And so that is something that potentially could happen. but essentially you're extracting resources from the facility for something potentially in the future. And, you know, in terms of standards of operations of businesses anywhere in the county, that could happen with any entity. It's not something that typically takes place. From a legal standpoint, I just don't know that that's something under Wisconsin law that would hold up in court. So,
well, then my example always is, why do we put a performance bond on a gravel pit for reclamation specifically?
yeah, I mean, you know, I'm not saying you're wrong or I'm not going to say that from a policy standpoint that policy is a poor choice. I just think in terms of Wisconsin law, as these things come forward, I just don't know if that's something that would hold up legally. So I think that's something you want to think about. And let's look at different options too in terms of ensuring for the public health, safety, and welfare and financial well-being of the county. There may be other options, and you know, you can work with your staff and corp counsel and consider those. I don't know if an upfront bond in terms of the operations would be the best option in terms of legality, if something like that would hold up under Wisconsin law in your court system.
But then you just listed a general thing.
Okay.
I don't know general. Well, I mean, I'm just a common person. What exactly are you saying? You can put it under something else. Just steer us in that direction.
So, well, I guess I'm not sure what you're asking.
Well, I just asked about performance bonds, and you said, well, really, that doesn't go. You could steer it in a different direction to protect the public. What direction should we steer to?
You know, again, in terms, if you're thinking about a CAFE ordinance, I think there's many options from a standpoint not involving money, but you know, I think if you want to extract money from the operation, something has to happen before you can do that in order for it to stand up legally. And so, you know, and again, I would refer you to your corp counsel as you develop policy and consider options. But you know, I'm not prepared to offer alternatives. I can do some research and look at what other counties are doing, and then maybe email you on that. But you know, I don't have any sort of a spur of the moment question, so I don't have any alternatives at this point. But I can come up with options for you.
Okay, thank you.
And I would say also, maybe what I could do is look at some of the best practices in terms of the performance bond and some alternatives that might be suitable for you. And in terms of what other counties are doing. Okay, yes, sir.
Instead of performance bonds, would it be more legal or advantageous if you had an insurance plan? I mean, like insurance plan that we carry on our vehicles is in case that would happen. And if there was a written insurance plan coverage, wouldn't that be better language than in performance bond?
Yeah, you know, does the county have it cover? I don't think it's a private facility, so I don't know that the county would have an insurance plan. Is the county have anything like that, Malia?
So what I meant was requiring the operation to have an insurance plan.
Yeah, I would assume that they would have that, but I guess I would refer to your corp counsel. Is anything like that exists right now? I've never heard of that.
I think the requirements that already exist at the state for approval by DADCAP and DNR would have some type of requirement, but I don't think we could require as a condition of a conditional use any particular insurance coverage, because it would be akin to, again, a performance bond that is expressly prohibited in Wisconsin statute when it comes to citing, and CUP is considered citing even though it's not a separate citing ordinance, because you're putting citing conditions right within the CUP. So a performance bond or an insurance policy that is supposed to act as a performance bond, because again, they're really functioning in the same way, would not be something that we could impose as a condition.
Thank you.
Sure.
We have Health and Human Services here. We're sharing our mic over here. So I apologize for being slow. So can we do a performance bond in the realm of operational permits? I want us to look at maybe some other options bigger than the CUP process. As I've dove into this with the lens of public health, I feel like we're really limited in what we can do up front with, for example, fees for application fees that don't allow us to charge for engineering or water quality testing or baseline, any of that stuff that we would need for health maybe health data before a permit was even issued. We don't have, and then we don't have this performance stuff, and John's talking about maybe an insurance. We're trying to think through this so that on the front end, we can have the developer prove that they're protecting public health.
Mhm.
And then on the back end, we're not dumping and running, and the taxpayers in Polk County are stuck with a cleanup.
Right.
And then I have a few other questions in the middle, but we'll start with that.
Well, okay, on the fees, so I was recently involved with sort of a work group with some of the ag industry, okay, and we talked about the fees, and it's a contentious topic. And so there's been a cap on the fees for the permit applications, okay? And it kind of went back and forth, and they said, Dan, I talked to the Farm Bureau, talked to DBA, good organizations. And they said, what we need, Dan, is regulatory certainty, so these caps are very much necessary. But there are limitations on these fees, no question about it. And I said, what the county needs is real and actual costs, okay, right? Okay, and so that's kind of what I was pushing for. And then they said, well, real and actual cost is a problem, and here's what they say is, you have, pitchforks and torches, and people come out, they demand the counties do all these studies and add layers of bureaucracy to the permitting of the CAFO process, and then the cost gets pushed onto them. They would argue that some of the studies and some of the things you're talking about may be unnecessary. I don't know that. Don't have no opinion on that. Whether it's, but essentially, a lot of the ag industry would argue that prolonging the process and generating excess costs limits their ability to establish the facility, and thus there needs to be these caps in place. Anyway, the conclusion of this work group, and it's because the NR rule is ending, okay, and the DAD cap rule are ending. So they wanted to establish a new process. We had attempted to get this administration of the CAFO permits 4 through DAD cap, 1 through DNR. We attempted to have that done in-house with the DNR and DAD cap versus our county staff, so that we could save money, quite a bit of money for the county. Ultimately, the bill died, and it was too controversial. It's a controversial topic. But what I would say, and what we're trying to get established, is real and actual costs for these practices in the counties from a policy standpoint at the Counties Association. Now, that being said, when you do think about your fees, there's going to be political pushback if the fees do get excessive. If someone comes out and says, picks an arbitrary number and says, the fee is going to be $1 million, and you can't justify it, or it's not based on real and actual cost, legislators will see that and they'll say, the ag industry is not being treated fairly. And then they'll change the law and start to put caps, more stringent caps on these things. So all I can tell you as decision makers, when you think about your fee structure, when you think about your operations and how you want to move forward with a fee, you want to be judicious with that, just to ensure that legislators don't take away the tools in the toolbox that you have. I think that's the most important thing you can do. But to your point, there are limitations on the fees, but I can understand where you'd want to have more tools to do that.
The $1,000 doesn't really give us much to work with at all. I mean, that buys the paper for the staff to print it on. And so any questions that would come up from the public, which are, I think, genuinely concerned about public health, we wouldn't be able to answer them unless the county took the hit for answering that question. If we need to hire an outside consulting firm, outside engineering firm, whoever, we have to take that hit. And under CUP, I get that we can't do that, but can we do it under an operations scenario, an operations permit?
Yeah, that's not something I would say you could do. I don't think that's applicable under law. But I'd refer to Malia, and she's your corp counsel. What are your thoughts on that, Malia? I don't believe that that's something that would be permitted under state statute. But go ahead. Correct me if I'm wrong.
No, you're absolutely correct.
Okay. Yes, sir. Did you have more questions, or I can come back?
I do. I can come back. That's fine.
You're just saying. Let's see, question. I'll just go through them real quick, and then maybe you can answer since they want to.
Yeah.
If you have a CUP and we develop this, who approves if the conditions are valid in it? There's a lot of talk. You bring it up. Oh, that might be legal. That might be not. That's policy. When we do a CUP, I just know with our shoreline ordinance, we have to have that approved by the DNR.
That's right, yeah.
So who approves the language in the CUP that, how gray is it? Who oversees, is that just strictly our corporation council? Or
Well,
does the state or the counties get involved?
Yeah, I mean, so in this case, it'd be DADCAP. They have oversight, and it depends what component of the, because again, there's 4 permits, and then those are DADCAP permits, and there's 1 DNR permit. DADCAP and DNR have oversight depending on the area. Generally, DADCAP, I would say. You do have some discretion, and if you do enact whatever it might be, and you're elected officials, you can do whatever you want. But I think here's the point I would make. You do want to consult with your corp counsel. You do want to consult with your DNR and your DADCAP officials, and see what they think about what you might be doing, because I think the goal would be to avoid a legal challenge. You want to make sure you're on solid legal standing. Now, you may enact something, and if no one requests, tries to go into the permitting process, no one will say anything. I mean, it can be in place for years, but as soon as they do, and it doesn't jive with state law, then they're going to go to court, and you're going to have problems. And I understand that people want to try, and everyone's got the best of intentions. They want to try and, represent and protect public health and protect the citizens. But you want to make sure you do so in a manner that's, in alignment with state law. And that's, I think, the most important point I can make, because it will cost the county money if you don't. But yeah, I'd say,
it's not required. You're just saying it's good practice.
It's very good practice. And DADCAP, if something gets attention or is in the news, like this county is doing that, they may call and say, that's not illegal. And so I would definitely consult with DNR and DADCAP, things like that. I think that's important. You have a corp counsel. There are many resources. You can contact WCA. We have lawyers that can look at it for you as well.
Okay. Then the other question real quick was, if we do get a conditional use in place and we run someone through our conditional use process, and they are obviously going through the state and through DADCAP, and something in our conditional use process, we feel like, hey, we're good. And these state agencies, what do they do with our conditional use? If we put these conditional uses on them, and then they go to the state, what happens if there's conflict between what the county says and the state's getting ready to issue the permit? Do they go, well, that's fine, whatever you guys want to do, that's your own deal? Do they still issue it and not follow our conditional use? I mean, how does that work?
Well, I guess I would say this. No, it has to be, these things all have to align within the county zoning code. Okay. And the CUP is part of that.
Sure.
And I would say that the 5 permits, there's 4 DADCAP related permits, 1 DNR, have their own unique set of criteria for state approvals,
Sure.
DNR and DADCAP approvals. So they're sort of separate, but it would have to comply with all
They
your...
recognize our conditional use in their process.
Correct.
Okay. And then last one was the cleanup or the state. So when I hear about the cleanup or the county hanging the bag and the insurance idea, I just think as a business owner, anyone that works on our projects, we have to be a named insurer, right? So that way, obviously, if there's a problem on the job site, we can file a claim against their policy. We don't have to go to court. We can just file that claim directly against that vendor or that supplier. And I kind of hear that a little bit from John's comments, is that, and it kind of goes to this final question, we have a conditional use process in place, and we do have someone that dumps and run, or, hey, I'm out of here. Is the county, through the process, is the county holding the bag for cleanup? If we have a conditional use process, are we responsible for paying for that cleanup? Or is it through DNR and DADCAP permit processes? Are they the ones coming in and doing the cleanup? Who's paying for the cleanup?
Generally, it would be the DNR or DADCAP. The county would not be responsible. It's private property. Now, your county does a lot of the enforcement and things like that. I wouldn't say the county is responsible for the cleanup, and that would generally, the DNR has the resources and dollars to do that. I would never say that it won't ever cost the county money, because you have staff and there's going to be hours expended and things like that. But I think generally those costs would fall under DNR.
On-site cleanup issues would fall on the state.
Correct.
Okay.
I think typically with other types of facilities as well, that's typically the case also.
All right. Thank you.
Yes. Okay, we got
One,
I didn't mean to cut off your public health official, so I go back to her.
Yeah, let's just loop through. And just to loop back on Chris, I think we have that concerning example in our county south of us with the cleanup And I don't know what St. Croix County had to pay for the Emerald Sky issue, but I know they were begging for the DNR to come in and help, and the DNR didn't have the resources to come in. So I just think about that when I think about us. So I like your idea of the named, like for business, I have to do the same thing. You have to be a named insurer. So maybe that is some workaround. But we all read your articles. We've all been scouring away.
Good.
Yeah, thank you
It's
for
nice
that.
stuff. Quality. And we try to do that too. We try to get good experts and good information for you. And so keep reading them.
We read it.
Call with questions.
We read it. Everybody's been saying, did you read? Did you get it? Did you get it? I got a text before it was even out of my mailbox.
Well,
So thank you.
Yeah, good.
So, but I'm curious. I see like Ashland and Douglas County, and now locally we have Eureka, which are these ordinances which have much more robust kind of conditions around them. And I'm concerned that we're kind of barking up the wrong tree. And so we got the public health piece that I don't feel is adequately addressed. Maybe we can address this with some sort of named issue at the end for insurance. Maybe that would assure me. But I feel like we keep saying Eureka isn't viable, Bayfield's not viable. Can you speak a little bit more about why those are not avenues that we should go down to make cover some more bases around public health?
So a couple of things. So the Bayfield ordinance is sort of is there another county? I guess I won't get too much into Eureka, but I understand it's sort of similar to what Bayfield has been trying to do. So how shall I put this? I think with your CUP process, you can be pretty specific to the things going on in your county, and another county may do something doesn't necessarily mean it's right for Polk. I don't want to come out and say that the Bayfield County ordinance is not legal. I wouldn't do that, and the court hasn't ruled on it, and I'm not a judge, so I'm not going to do that. However, I think in my discussions with the individuals in the ag community, I think it's something that would likely draw a legal challenge. And so, and again, as I stated before, I think a couple of things. If you want to accomplish protecting the public health and welfare, you want your resources to go for those exercises and not to defend the county against a lawsuit. I think the goal should be to further the public benefit, to further public health, to further public safety, that your resources be expended on that. I don't know if Polk County is a county that's got tons of money and they want to spend them on lawyers, but I do think the Bayfield County judge may come out and say, yeah, this is, I think you're okay. But, and that may work out, it may not. But they're going to spend money defending it. I think that's pretty likely. And so I think that's what you want to avoid. And so you have to decide, your elected officials have to decide if that's the direction they'd like to go. And again, I'm not going to tell you not to do that. I'm not going to tell you to do that. But I'm going to tell you, I think that's a situation with the language they've used, which some would have pointed out to me run contrary to what's in state statutes. When that happens, people who have an interest in furthering agriculture or want to establish a facility, they're going to hire lawyers, and they're going to come in, if they want to come to Polk County, they're going to come in and say, hey, this doesn't appear to jive with state law, and so we're going to challenge it, and we don't feel we should have to meet whatever requirements are not jiving with the statutes.
All right, to go off that,
Okay.
has Bayfield sent theirs in and been approved? According to your article, it's sent to the DNR and the DADCAT to be approved.
Sure. And
Has that been done?
yeah.
Do we know?
No.
Has anybody sent one in that's been approved?
Well, I don't believe that's the case. But the question becomes, and I think it's this, because it's a very aggressive ordinance, the ag industry has looked at it and said, we will challenge this. And so it's going to lead to litigation. And ultimately, I think it's going to be a court who decides whether or not it's legal, or whether the ordinance itself is in compliance with the state statutes as written. And, I would leave it to your corp counsel to get into the specifics on all that. But I would say, though, as elected officials, and I would advise you to do whatever you can to avoid litigation, because litigation takes your resources away from your goal of protecting the public health and puts them towards paying for attorneys to defend the county in its decision making. And I think that there are ways through your CUP process or through other avenues, and you can work with experts, you can work with our attorneys. We're happy to help. Myself, Andy Phillips, Malia, we're happy to work with you to develop alternatives that I think would not lead to litigation in the county or against the county. And I think that's probably should be your goal.
But like in 115, our zoning, it has to be approved by the DNR to be able to implement it.
Sure.
So why isn't this the same thing? So if that ordinance is not approved by them, is it not legal or what is it?
So, you know.
If it has to, if it says by state statute, you have to send it in. to
Correct,
get it
yep.
approved.
Yep, okay.
Okay, and if we don't send it in, what happens? Like I said, did Bayfield send theirs in? Is it approved?
I'm sure they've gone through the process, and it may have even been, you know, I don't know this, I can check on the status of their ordinance. But what I would say is,
If you don't send it in and it doesn't get approved by them, it's not enforceable. Is that correct?
right, yep.
Okay, so we have to find out if anybody sent them in.
Well, I can check the status, but whether it's, and it could also be approved. And I would say that, you know, DADCAP and DNR do have a tendency, I'd say, to give some deference to the local governments, in my experience in watching them. But the issue is you get to a court and people are saying this is not in compliance with state law. I think the court has a higher standard. The burden of proof, you know, that sort of thing is a little less flexible. You really do have to align with state statute.
Okay.
If you're in a
But
court.
now-
I mean, depending on the judge and things, and I'm not a judge, but you know, I do think you don't want to be in court because then you might believe in the statutes, you want to defend it, but you are then expending resources on something that you'd otherwise put towards public health and things like that.
What's the order of the permit? Do they start at the local level or do they start at the state?
So the permit,
What order does it come?
so there's five permits. There's
Correct.
four DADCAP permits, one DNR. The locals administer the permit. Now, the CUP relates to your zoning code and your ordinances and your land use in your county, which has to be complied
Does
with.
it start here then? Do they start
The
with us?
permits?
Yes.
Well,
Or
the
do they start at the state and then work down to us?
The permits, all the rules associated with the state permits, the state statutes and state code are all in those five permits. Those are all state regulations, okay? So we only administer those permits.
Which one's first?
What's
Where
that?
do you start? What permit do you get first?
Off the top of I couldn't tell you that off the
So
top
it
of my
doesn't
head.
start local.
Well, the locals administer the permitting process.
I know we administer, it, but where do they come and get a CUP before they get the other ones? Do they come to us?
I don't know if there necessarily has to, yeah, you'd have to go through the local process first before you got your state permits. You have to be in compliance with the
So
local
you have to
ordinances.
start here with us. So
You're
they
correct.
Start here,
That's
so
correct.
the zoning and these
Yeah.
start first,
Correct,
then they go after the state.
correct. That's
Okay,
correct.
that was the
Yes.
order I wanted.
Yes.
Thank
Okay. Go ahead.
you.
We can,
Who else?
I don't want to go out of order, but, you can go.
Okay, I hope I can explain this so that it comes out.
Sure.
One thing that I'd like to stress, we have our study group report here,
Mm-hmm.
and our committee, it says here, large-scale swine facility. We are only dealing with swine, nothing more. So the public is.
Hogs. Hogs. All right. Yeah.
So the public sees what's happening in the north. They see what's happening in one town, and they want protection. So that's what I'm hearing from my constituents, all over, not just in my district, all over the north. And it's hard to express to them, well, you know, maybe this might happen. You know, and I'm just getting this out there as my feeling of why I believe we need to have an ordinance.
And when you're saying maybe this might happen, you're talking about the establishment and permitting of a concentrated animal feeding operation.
No, I'm talking about,
You're talking about the ordinance.
using the saying, well, you know, we might get litigation on this. No, you know, I mean,
Oh, yeah,
that's
no,
what's really
absolutely.
hard to explain. So I want to bring that concept out there.
Sure.
That we are looking at doing an ordinance.
And I think this, in terms of the public, you know, here's my answer to that. All these things are hypothetical, whether you get sued, whether a CAFO even tries to establish itself in the county, we don't know that. And so I don't see a problem with having a discussion. I think it's good you're having a discussion. But rather, you know, there are many tools at your disposal to regulate and protect the public health, safety, and welfare. Maybe not as many as some would like, and I understand that. But the law is the law. All I would advise is to work with your corp counsel, work with your staff. You've got an administrator. I've met with him many times, several times, not too many, but several. But work with them to find the best alternative under state law, protect yourself legally, and address the concerns of the public. And I think you can do that with the tools you have available. And I've seen counties do it. There are many options out there, you know, and you can choose to be aggressive. You're elected officials. It's not up to me. It's up to you. but I would only advise that some of the more aggressive approaches are increase the likelihood that you're going to get sued, your county is going to get sued, which deters from the goal of protecting the public health, safety, and welfare. Because I think from a county's association perspective, it's better that your resources are used to fund your zoning department or fund whatever else it is you might want to fund, other than pay a law firm to assist Malia in defending county from a lawsuit. Because I've seen this happen, and it can get very, very expensive, and you sort of get into this battle of we're defending our ordinance, what we did was right, and maybe you are right. It's a matter of opinion whether you're right or not. But if you're spending resources on defending it, it's not furthering your ultimate goal with the ordinance to begin with, which is to protect the public health, safety, and welfare.
Do you know?
You can call, yeah.
Well, just to that point, I'm just curious why the Bayfield piece has never seen a legal challenge for 5 years. Do you have any feel for that? I mean, that's.
Yeah, I just don't, I think there was discussion about having CAFO up there, and I don't know if they ever came. It's never been challenged, so they never challenged it, I guess. But, in my discussions with our attorneys at WCA, with individuals in the ag community, it's been suggested to me, and the ordinance is, again, not that it wouldn't survive a legal challenge, but I'm not a judge. It's not for me to say whether it would or not. But if there is a legal challenge, it's going to cost the county money. And so, to avoid that, I'm not saying the Bayfield approach is not the correct one. I'm saying, no, it is more likely to lead to litigation in the county. And that's something that should be part of your consideration when you decide how to proceed. Sure, yeah, go ahead.
Following along with what you said, or implying on the ordinance, you said there's other tools.
Yep.
How do we actually access these other tools? I mean, I don't know what the other tools are. You just say there's other tools. Don't you have a list?
Well, and again, when you get into your, I can provide you with different zoning options, and you can talk about zoning 101 or how you want the land uses to look in your counties, but there's the CUP process with conditions, and I think there's many reasonable conditions that would certainly survive a legal challenge that you could place on an operation. So I think that's a critical tool. But I think you got to know what you're looking at. I don't know if there's any proposal in the county. We're sort of talking about, well, hypothetically, what could come, and maybe we should have this ordinance, and I mean, that's all up to you. But I was asked about the Bayfield County ordinance, and my response to that is it's certainly an option for you to consider. All I'm saying is that increase the likelihood that the county, should a CAFO decide to try to locate here, it would increase the likelihood that you might face litigation.
I can add to the Bayfield County ordinance. It was rejected by both DADCAP and the DNR. Yep.
They talk about conditional use ordinance, and then the comments are, well, the county is allowing swine people to come to Polk County.
Oh,
To come to.
you want me to use this one? Okay.
They talk about that Polk County is drafting this watered down conditional use process, which I like that you said during the conditional use process is when you actually get public comment. That's how you develop your conditional use.
Sure.
So we have a draft out now, proposal to go to public hearings, public comments, public hearings it'd be. But could you talk a little bit about the difference of a conditional use and an ordinance? And, I guess I just kind of want to let the public know we're actually trying to do something to have some protection in place. Because if we don't do nothing, they're coming. If you think they're coming, they're coming. And what we're doing is not encouraging them to come, right? We're actually doing something to put some conditions to protect us.
Well,
Can you address where we're at right now in our process, or where we're at, and the difference between conditional use and just a standalone ordinance?
Yeah, so again, the conditional use is going to apply to any entity that wants to do a specific operation, and it's sort of a trade-off. So they'll meet certain conditions, and then in exchange for that, they meet those conditions, but they can operate. And they may not be in line with the use. Let's say it's zone commercial, or zone something other than ag. by certain conditions, they can, then it's almost like getting a variance, you know, but they have to meet conditions. A variance, they just allow, you know, an exception to the rule. In this case, conditions are met. Those conditions, of course, which I think are important, and that's the tool I would refer to and say you take a look at. What can you do under state law? What conditions can you implement that would ensure that there's additional protection for the public health, welfare, and safety? And I think your attorneys, and you know, we can send best practices on what other counties have done as well. I appreciate knowing that the Bayfield County ordinance, I was not aware of that. That must be recent, but I've heard many different things about that ordinance, and it's the subject of a lot of politics. But it's good to know that the DNR and DADCAP are rejecting it. Probably not going to survive a legal challenge in court.
Well, Bayfield is now litigating the issue with DADCAP and DNR in state court, so they're actively involved in litigation.
Yeah, but with the conditions, and again, it's going to depend on what proposal comes forward. You know, it's hard to consider hypotheticals, but you know, for instance, in shoreline zoning, which is a common practice, someone will want to, you know, go beyond the square footage of their property. You know, with shoreline zoning, if you're within 75 foot of the shoreline, 75-foot setback, you know, it's hard to ever expand your footprint. But they might allow you to extend your footprint. Let's say if you are rebuilding your structure, you want to extend your footprint. You know, if you allow for more impervious surface area, or if you have on the shoreline, you know, tall grass to avoid runoff, or if you slant your roof away from the direction of the water so that, you know, they're trying to avoid runoff, things like that, protect the water. Those are sort of conditions that you could also place on a CAFO. Now, but there'd be obviously other examples for
So I'm going to interrupt one point here. So we had a resolution that extended a moratorium, and we said that we would not allow CAFOs to be developed in the shoreline setback.
Right.
Is that okay to do?
Sure.
Okay, so that's a condition that you would say would pass the test.
I think that's definitely
that we could actually say no CAFOs in any shoreline protected area.
Yeah, you know, and I think the goal with zoning and with conditional use permits and things of that nature is that you do determine the appropriate uses for your land in various parts of the county. I think if you get into a situation where I think the zoning code needs to be sort of futuristic look of how the county wants to grow, where it's appropriate to grow, and what should grow in a particular area when you think about zoning. But I wouldn't say it should be used to preclude any sort of type of use forever into infinity. Okay, the conditions are in place to further the goal of the ordinance, the zoning ordinance in this case. The zoning ordinance in this goal, I'd say, when you think about CAFOs in general, you're thinking about air, you're thinking about water, and how do we protect those things, quality of life. And so those are sort of the goals, and so the conditions should be based on achieving those goals. And so if there are conditions that are associated with the ordinance, you know, the gentleman asked, well, gee, what about this 5-mile rule for the owner-operator? And in fact, if I was the owner of a CAFO and had to live within 5 miles of it, you could assume, I think, yeah, you know, maybe he'll be more attentive and ensure that this is operating properly and that there's not environmental damage or spills. And maybe in theory, you could come to that conclusion, but there's no scientific evidence. You can't substantiate it, as was pointed out in state statutes. It says you got to have substantial evidence to demonstrate that you're going to get a certain outcome. I don't know if you have that. You're making an assumption because he lives there, you know, he's going to be more attentive to the environmental situation. That's potentially true, but not necessarily true. And in fact, he may say, I don't care, I'm fine, you know, and operate just like if he lived 100 miles away. So, you know, I don't know if that's something that would pass legal muster, as opposed to say, you know, the person who's got shoreline zoning and they're getting a conditional use permit to expand their footprint and they slant their roof because we're going to prevent runoff. We know if we slant the roof away from the direction of the water, that's going to reduce runoff. We know if we increase the impervious surface area, don't allow them to blacktop their driveway, well, that'll allow for the water to go into the ground and more impervious surface. So those are things that are more substantiated based on science that, you know, then would probably pass legal muster if they faced a challenge in court. Does that answer your question? Yes, ma'am.
Can we, I guess I have two questions. We have kind of an issue in our county, and that is that the CAFO focus has been in our unzoned towns. So in the unzoned part of our county is a bit vulnerable right now, and I'm trying to figure out how we might address that. And then the second piece is, if we could go back to Doug's question on some specifics. So we're not lawyers, and we don't dive into the statutes always, but often we do. But I would like some like specifics that we could add to the CUP that are addressing our health and human services piece.
Mm-hmm.
That you, I mean, maybe point them to our corp counsel and I can work with,
Yeah.
but I know you reference them and you say we have options, but we need to know what page and specifically what options.
So
you
the
could give
second
us.
part of your, so the second part of your question, and I'll address the unzoned towns and more general zoning later. What I can do is I can go through and look at what other counties are doing, best practices, and maybe get you something like that. And then you can consider different options. But I can send you information that would allow for the county to continue their dialogue and look what's going on around the state. And of course, what I would call best practices, so that you have those options to consider, you know, amongst this group and your county board. To the first part of your question about unzoned towns, and Wisconsin zoning is sort of a patchwork. It's a very strange thing. Polk County has county zoning. Not every town is in it. Every 10 years when they do a comprehensive rewrite of the zoning code, you know, the towns have an option if they want to stay in county zoning or if they want out. And typically it's a partnership between the towns and the county. And I wouldn't tell the towns what to do, but, you know, when they rewrite these zoning codes, you know, with their comprehensive rewrite, usually the towns, they participate, they kind of tell the county, well, here's what we'd like to see. And they incorporate it into the zoning code, and then the towns decide if they want to be part of it. And I think if the partnership stays intact, a lot of the towns, if not all the towns, because there are many counties, because I have a map in my office of which counties have county zoning, which counties don't have county zoning, but it's town zoning, and which counties have no zoning. And then in this case, in the case of Polk County, in this county, you have some towns that are in and some towns are out, which is not unusual. But I would encourage in that rewrite for the towns to participate, and so that they're comfortable with it, so that they get into county zoning. Now, it's a town decision. They may not want zoning. That's up to the elected officials in the town. But I think the best way to address an unzoned town is say, hey, you know, you don't know what might come down the line. You don't know, you know, there's certain uses you may want to allow and may not want to allow, and through zoning you can decide what appropriate land uses are. That's what zoning's all about. But I would encourage through that comprehensive rewrite for the county to work with its towns, encourage participation, and encourage them then, if they're comfortable with the final product, to be part of the zoning code and to get into county zoning. But that again is just to finish, the zoning code is typically administered by the county. Even when the towns have their own zoning code, they have the county zoning office that administers it for them. And so that's sort of the nature of the partnership. But I think ideally, you have a countywide zoning code that the towns buy into. It's a real partnership, but then you have a little more consistency across the county, which I think is a benefit to the citizens and businesses and anyone trying to do anything. But it is up to the towns if they're going to, when you do this comprehensive rewrite, if they want to be part of that or not. And it's a complex process, but I have my map, and you know, some counties have no zoning. Fond du Lac County, for example, there's none. Up here, you know, it's a patchwork. You know, in order to maximize the number of towns that are part of it, though, you want to be inclusive and make sure they have a say and be flexible. But you know, and typically it works pretty well. A lot of times they do their rewrite and every town's in and they feel they're heard and they're good and that's it. And so, you know, sometimes it works out. Other towns, you know, where there's been issues or they want more control over the land, or the town board doesn't trust the county zoning department, or they're at philosophical odds with the county board, they'll be out of the zoning. They won't be part of county zoning. They'll have their own or have none at all. And so they wouldn't have any zoning, so no. Correct. Johnny.
The towns operate under home rule, which really is the rule. But under water quality and that, aren't unilaterally across the state, they still have to operate under county and state rules with that. And that.
Sure, if there's a county ordinance, you know, in an unincorporated area, then it would still, as it relates to non-zoning matters, they are still applicable. And same with the DNR codes and state laws, and
exactly.
it's all applicable.
And one more comment, as far as like a 5-mile radius, like on public protection or officers, some counties, they have to live within a town or village or whatever. You have to live within Polk County, but then like we gave permits for like in Taylor Falls and right across the St. Croix County line. Those are inclusive permits. So even though you have that you know, that's always an option.
Sure.
For them to be, outside the ordinance.
Yeah, yes.
I got
Yeah,
a
you bet.
follow-up too
Okay,
on
sure, no
Amy's
problem.
question as far as the unzoned townships, and just townships in general, because that's what I hear from as chair. I'm getting calls from the townships, and they just want to make sure that the county is listening to the townships process.
Yeah.
So we can have language in our CUP that requires that even more local level involvement, that we take their recommendations during our CUP process, correct?
Oh, yeah,
And
absolutely.
whether they're unzoned or zoned, we can help those local townships.
Well, if they're not zoned, that's you see, this is why I encourage.
So if they're not zoned,
Well, then they're not part of they're not in zoning.
but
So
if we have a
you
condition.
can talk to them and if they have suggestions, but it's not going to affect the town because they don't
So
have
then they
zoning.
don't have to come to us for conditional use, then you're saying?
But no, if it's unzoned, so I mean,
Oh, I
obviously they're
gotcha.
not, yeah, let me clarify. So this is why I would encourage towns, to participate in the rewrite of the comprehensive
Interesting.
plan, in the zoning, the rewrite of the zoning code.
We would not have it.
I mean, they should participate. You know, I'd say I'm a proponent of county zoning, and participation in the rewrite. You know, there's an old saying, if you're not at the table, you're on the menu. You know, and a lot of towns don't want, you know, a lot of towns don't want zoning. I get that. And they want property rights, or they have philosophical disagreements with whoever's in power at the county. I understand that, but I think, in my point of view, I guess, I think it's good if you participate in that process. Typically, in not always the case, but in a lot of cases, in most cases, the county will accommodate various areas of their unincorporated areas, the towns, to get them what they would like to see in the zoning code. And thus, you know, it tends to work out. I've seen counties that are completely zoned, the towns are all in. Dunn County is an example. Western Wisconsin has a lot of them. No, so some of these towns that are unzoned, as you do your comprehensive rewrite, when was the last time you did your rewrite? Do you recall?
Last year, 2 years.
Okay.
Oh,
Just the last few years? Okay. So when it's rewritten, they can participate in getting into county zoning. And so I would encourage it. I'm a proponent of county-wide zoning. I think it makes sense. But for it to work, you know, there has to be an inclusive process where the towns are all heard and are comfortable with it. Otherwise, they're not going to buy into the zoning plan. Thus, they're not in zoning. But yeah, and you can talk to whoever you want about your CUP and what it should be associated with the CUP. But it's not going to be applicable where there's no zoning, obviously.
So then they would only go through the state, the DAC and the DNR
Yep.
rules.
All the state statutes and requirements are applicable everywhere.
Now, we put in our resolution, though, that nothing in shoreline, so in an unincorporated or in those unzoned, those shoreline districts would be protected.
And I think we have this, so you got general zoning and shoreline zoning. Every town has shoreline zoning if they have a shoreline. The general zoning, not necessarily. That's the
Right.
patchwork is
Gotcha.
the general. But shoreline zoning, yes. And so in that case, yes.
That's all we could protect them in is in those.
In the shoreline zoning, that's true.
Gotcha. Okay.
So do we have any options, Dan, for, because this CAFO impacts is potentially it's bigger than one town. It's not like a little gravel pit.
Right.
And if they're unzoned, they can do the gravel pit and it really doesn't affect a couple towns over. CAFOs are different, and so it's a larger impact. What are our options for managing a CAFO that wants to site in an unzoned town?
You can encourage the unzoned towns to get into zoning. I mean,
That the ship of getting involved and signing in is every 10 years, and that was just last year, basically.
and I would say
And
this.
so, and they don't want in. I mean, I've talked to them.
Can you answer Amy's question?
Do you want a mic?
And so our comprehensive rewrite finished up in 2016, and the towns can adopt in at any time. If they adopt or they want to get out of county zoning, and that they have to give us a year notice. So, it's and they have to have a comp plan.
But I would say in the case of the towns, and I know you're thinking of CAFOs, but from the bigger picture, they're probably not going to want to be part of the zoning unless they're able to participate in the process, I would say. And then the most likely time for them to get involved in the process would be during the comprehensive rewrite. That's when there's buy-in or buy-out. But you know, his points are well taken as well. They can opt out. They can join.
They can hop in.
They can hop in. If they choose not to be part of it, and maybe their top consideration isn't necessarily a concentrated animal feeding operation, you know, but I would encourage them, you know, to consider being part of the comprehensive rewrite when it goes on in the future, or considering if they're comfortable with the zoning code, you know, adopting it. But that's a choice that those towns have to make. There are, of course, other regulations, state and county related to public health and other areas that still apply in unincorporated areas that are not applicable to zoning. But if there is no zoning, then you can't enforce the CUP, you can't enforce a zoning ordinance, and you can't enforce the zoning code in an unzoned area.
Yep, go ahead.
In our conditional use right here, we have all waste storage structures, including manure storage, shall be at least 200 feet. I had a call the other day on that, and I didn't understand her reference, but she said that it's required that they're 350 feet.
So is it is this a setback?
Setback.
It's a setback.
Mhm.
And again, specifically, if the state rules would have a setback of 350 feet, then that's, you want to align with that, I'd say. Okay, but
So
but
that
again,
is, there is that rule in the state?
I don't have the code in front of me, what the state setback requirement is, but that's something maybe Malia, if she had, I don't know off the top of my head if that's the case, but if it's written in this either
Right,
a DADCAP or in our rule or in state statute, then you would want to align any policy you have in the county with the state requirement. If in fact, and I can't speak off the top of my head, you know, the specifics, whether it's 350 feet, but you know, maybe Malia will find it, and I can follow up with you to determine if that is or is not the case.
Is there any other questions?
I appreciate you, Dan.
Yeah.
Yeah.
Well, it's been
Thank
great to
you.
be in Polk County, guys, and thanks
Good.
anytime, and I'm always happy to come. I did speak in this room once before to your Polk County board. I don't know if any of you were on the county board when I did that a couple years ago, but and they rang a little bell and it was a lot of fun. So. All right, well, thanks for having me, guys.
Yep, thank you.
You bet. We'll be in touch. Thank you.
Okay. We'll move on here to number 6. Does anybody have a conflict? We probably would have heard it earlier. So we're good. Number 7, as long as we have a few people here. Any other supervisor want to speak to anything that is on the agenda? Is all you can speak to. If not, we had it. Good. All right. Number 8, Parks and Rec.
Chairman O'Connell?
Yeah.
Chairman O'Connell, this is going to be a facilitated group process. I know in the past you've always tried to take a break.
This
will
will
be,
take a while.
this might be, yeah, this will take a while. So I don't know if you want to
Okay,
do
let's
that
take
now.
a short break. Yeah, it's gonna take a while.
And the
Thanks
guys
for
can
the
get set
warning.
up. So, thanks.
All right, let's take a 10-minute break.
Remember, we're gonna have a bias for speed.
We're up and running? Okay. Parks and Rec.
Hi, good morning, everyone. Good to see you again. After we're looking at the agenda and seeing the deliberations that would be coming potentially for the Stour Trail, we thought we'd take a little bit of time just to go over kind of the process. Again, just mostly focused on what public input has looked like from the beginning of this through now. Just refresh your memory about all that. I mean, you guys all have all this information when it comes to the public comments from the get-go of this. So I thought I'd just kind of touch on a few critical pieces as we went through this. And then we'll talk about what your selection was to go to public hearing, you know, the SA3 alternative for snowmobiles and the EA2 for equestrian uses. Talk about some of the things that might need to happen with those alternatives, and then work with you to see if any of the new information that came from the public hearing that we just had had any effect as to how you feel about those alternative choices, and kind of get those alternatives put down on paper that this is what you want to go with, and kind of beef that up with some information as to why you feel those choices are the best. So in the plan, we need to list out what those use choices are for the county. And we also need to kind of have an explanation as to why the county, you know, as you as supervisors felt that those were the best choices for the county to have on the trail. And then we'll talk a little bit about next steps to wrap this up. Okay? That's good. Excellent. All right. So way back, 2018, this is kind of just a snapshot of the first phase, the survey that we did. We had, 18, 20 questions in there, but the main one that talked about what you feel is the best use for Polk County. This is how it stacked up for motorized, multi-use, non-motorized, multi-use, and multi-use, just to kind of refresh your memory. It's pretty evenly split if you look at the two categories for multi-use, motorized, and multi-use, non-motorized. And it's kind of a theme we've seen throughout this, is that the public's pretty split on some of this. Again, just taking us all the way back to where it was a few years ago. At the public hearing that we had at Unity back in July of 2018, the verbal comments, people that came up and spoke, split 36 in favor of non-motorized and 19 for motorized. And then you'll see a theme. We try to categorize the information that came to you in terms of public input as to, so those that are wanting to advocate for changes in trail usage, and those that are wanting to advocate for the uses to kind of stay the same. And the slide on the side, on the right side there, showcases the written comments, email comments that came in, and the total numbers for those. Good. So this past fall, with Tool Design, we held an open house down in Amory, and there's a sheet of form to fill out as to preference for the two different uses that are being considered, snowmobiling and horseback riding for the Stour Trail. And this is kind of how it shook out. It's legible. So you want to add snowmobiling to the Stour Seven Lakes Trail. 54% of the respondents said no, 42% yes, 3 said maybe, and 1% didn't answer. And for horseback riding, 43% said no, 37% said yes, 14 maybe, and 6 no answers. So again, we're kind of seeing that what we've seen all along through this process, that there's a pretty distinct split between those that are in favor of changing uses versus those that are in favor of keeping things the same. Then getting closer to today, back in February, we put out a Survey Monkey talking about the actual alternatives. So after we had gotten the alternatives from Tool Design of the 4 different snowmobile potential alternatives, along with the 3 different equestrian alternatives, we put that to a poll online, and this is how the results shook out. So SA1, 802, so that's not allowing snowmobiles. SA2, kind of a hybrid look at it. So the main safety issue around Amory, just west of Amory, providing a new way to get to there, but the rest of it still remains the same for no snowmobile use. SA3 allowing snowmobiles on the entire corridor without any changes, and then SA4 allowing snowmobiles on a portion of the trail as shared or separate trails. So you see how those votes tally up. Equestrian alternatives, so we kind of have the same thing. You know, don't allow equestrians to happen. You see the total there. Allowing equestrians with no changes, kind of like SA3, and then separate trails and the votes associated with them. So we have, just like we did with the initial survey back in 2018 for public input, we had a lot of public input on this stuff, you know, thousands of people. So just a different depiction. The previous one was the survey monkey results from February about the different alternatives. This is what was received by the Parks Department on written results for those same 4 choices for snowmobiles, and then the 3 choices for equestrian. You can see the vote totals. Again, I'm just refreshing your memory as to what the public has said along the lines here. And then the totals. So we combine the written comments with the survey monkey for the different alternatives, and this is how the total amounts shook out in terms of those in favor for the different results. And finally, the public hearing that we just had with the video comments, split right down the middle. 15 of the 30 that showed up said they were in favor of keeping things the same, and 15 said that they would be in favor of changing trail usage. And then the written comments that were received, again, by the Parks Department, 120 came in for keeping the same uses, and 13 came in for changing trail uses. That's, again, just a brief snapshot, just kind of picking the parts that showcased how people felt about the different uses throughout the time here in Polk County since we began this process a few years ago. Now we'll talk about kind of what we're here to talk about today, which is finalizing the use selection for the trail. And I'll have Ben talk about what the alternatives were that you guys selected for the public hearing, SA3 and EA2.
So as we remember, SA3, the snowmobile option 3 was adding snowmobiles to the trail with no changes to the trail surface. That doesn't mean no changes to the trail, because we're going to need to put signs up, maybe some parking modifications throughout the course here. And that goes along with the equestrian alternative 2. It was EA2, which is opening the trail to equestrians with no changes to the trail surface. And when I say that, I mean, we're not widening the trail surface, making a separate trail. We're not kicking it out another 5-6 feet. We're keeping the trail as is, but we are going to need to put up signage and maybe modify some of the parking facilities along the way. So equestrian alternative 2, the few changes that have to happen to make this option viable, you need the minimum trail width of 14 feet. We have that. We don't need to do anything there. Vegetation will have to be cleared. Equestrians require 12 feet of vertical clearance, whereas pedestrians and bicyclists require 10 feet of vertical clearance with the trail vegetation. So that's going to have to be done. As I mentioned, signs and regulations are going to have to be put up to educate the public, educate non-equestrian folks on how to interact and how to treat horses when you come to horses on the trail, as well as educational signs for equestrian riders, you know, talking about specific guidelines we've set forth on the trail. The snowmobile. Sure. Yep. There's an equestrian group, the Northwestern Equestrian Alliance, I think it's called. They have provided the county with kind of a statement of support. Nothing official yet, but they've said, hey, we're here to help. We want to be a part of this trail, and we want to help out with maintenance. So having an official MOU with this group is something that we're going to need to pursue. And they're going to help take on some of the costs and duties associated with maintenance. So the snowmobiles, again, same thing. We need a minimum graded trail width of 14 feet. We have it. We don't need to make any changes. 2-foot maintained shoulders off of the 14 feet. We have that in most places. There is going to need to be a little bit of brushing that happens, but that happens every year. Again, vegetation will have to be cleared to a height of 12 feet, which will jive with the equestrian requirements. Signs and regulations. This is going to be more important with the snowmobiles. We're going to need to put in speed limit signs, more caution signs. We have a few fences that are lining the trail on steep drop-offs. We're going to have to sign those. So there will be some cost incurred with that. I would anticipate that a portion of that cost will be shared with the snowmobile club in order to sign those, but probably less than $5,000, which is what we've kind of the number we've figured by the number of signs we need. And then updated MOU with the snowmobile club. That's going to be a pretty simple process. We just need to add these new miles to the existing MOU we have with the snowmobile club. So the snowmobile club is going to take care of all the winter maintenance like they do on the Gandy Dancer and the Cattail and Sawmill. So they're going to maintain the brushing and the clearances. And then we'll work in the summertime with the Friends of the Stour and the equestrian group and the snowmobile club to get projects done in the summertime. So those were the changes that have to happen in order for these uses to be put on the trail. There are a few changes that don't have to happen right away, but things that we may want to consider to make the trail more accessible, user-friendly, marketable. So increased parking for trailers. That's both snowmobile trailers and horse trailers. The parking lots along the trail, with the exception of the one right in Amory, are pretty tight. You could get maybe 1 or 2 rigs in there with a trailer, but you're backing out. You're not going to be able to turn around. So that would be something that is pretty high on the list for an improvement, but it wouldn't have to happen right now to open the trail. Watering stations for horses. That would include a well, most likely, at these parking lots. There are creeks and rivers and swamps and stuff along the trail that folks can walk their horses down to and get them wet and get them a drink. But I think fresh water along the trail would be a good addition. A winter shelter for snowmobilers and cross-country skiers or whoever else may be on the trail. A winter shelter might be a good idea. They have them along the Gandy. Just a simple shelter, nothing too fancy. And then an option too, we've talked about users getting displaced or choosing not to use the Stour Trail as a result of snowmobiles being added to the trail in the wintertime. So something that the county could do is create an alternate cross-country skiing facility. We have D.D. Kennedy, we have Algren, we have trails, we just need to groom them. So we could talk about how to get that done and the costs that would be incurred with that too. That's about it for the improvements. Tim, do you want to talk about finalizing where we're at?
Sure. Yeah. All right. So again, to set the stage, we try to give you a brief overview of where we came from, public input wise, and then talk about where you guys were at in terms of the choices you made for SA3 and EA2, and some of the issues that might need to be addressed with those two. So we wanted to kind of begin the conversation about finalizing your allowed uses in this trail master plan by talking about the most recent public hearing. And if we want to, we can put those slides back up. But you guys all saw the videos and all received a packet of the comments from Ben. Just wondering if there's anything in those that either brought up a new perspective that you hadn't heard before that may cause you to reconsider one of your choices, or if there were different levels of input, or the fact that you heard more from one group or the other that might have changed how you feel about the choices of SA3 and EA2. Do you have any comments that way, or did it seem like it was the same stuff you've heard before?
Anyone, most of the ones it's about the same as what we received when I went through it.
Yeah, I just wanted to give you the opportunity to see if there was anything that struck you that was different or unique or something that you're like, oh, I hadn't thought about it that way. Maybe we should think about this differently. Anything?
What else? Okay.
How about any new, it's set up perspectives on the trail, any new concerns, anything that like struck you that this issue needs to be addressed before the trail would be opened, that might be new or something that Ben didn't cover in those previous slides, about, vegetation management or safety concerns, that kind of thing.
Go ahead.
One thing when you talk about safety, I sat in that meeting. I remember that today, Bob. And I know the DNR, that was their big concern too, was did we really address the concerns raised in public comment?
Right.
And just making sure that, if someone said, hey, I have a concern of safety, that we address it in the plan. And I just want to throw that out again, is that whether we heard it or not, is that staff would really address and tool design would address,
Sure.
Dust control, safety, potholes, maintenance, so if there, because that was the issue is that, well, if there was damage to the trail, it was the Friends group fixing it, and we didn't have county fixing it, or if we're going to wait for these Friends groups to fix it. Things like that seem to be their big issue, did we really address all the safety issues and how we mitigate the safety if someone calls in and says, hey, there's a washout on the trail. Maybe it's not even man-made,
right.
But whatever those issues were, we didn't address them well enough in that first plan.
Sure. Right.
So we have a contact number for somebody to call in on the trail? That was one of them for the safety.
If there's emergency contact information for the trail.
Emergency number, like a tree down or something completely blocking it or whatever.
Right. Yep. That's a part of the plan too, right, Ben? I think is emergency preparedness for incidents.
It is emergency preparedness and the contact number, and that's in the MOU section, the union groups, cooperators.
Okay.
So that network is set up.
So things like the speed limits and signage and education, those have been some of the things that we've talked about and have included in the plan as ways to address some of the safety concerns that have been brought up by the DNR.
Is there any time that you're aiming to want environmental friendly spray? You don't use any spray.
We do. Yep. Yep. Herbicide.
Oh, John, you can't jump in our meeting here.
Oh, sorry.
Your part's out.
That's apologies, Chairman.
It's a
That's
good
your role,
question.
not mine.
You can still answer for him.
Did they use basically a non-selective herbicide? So typically once a year.
Okay.
Any other questions or comments on concerns? Do we
I
feel like
just,
this
you
is-
know, when I took the trail, tour with Debbie Peterson that year, her comments were, we went down the trail in a county vehicle and she was showing me the whole trail. And we got to a point of the trail where the trail was underwater, a chunk of it, at probably more the west end of it, down by Lotus somewhere.
Sort of swampy
And she
area.
made a point of, there's beavers, there's something in there, and she was concerned, like, no one notified her that part of the trail was underwater. And, you know, that's, I guess, concern is, you know, does the county, you know, if the county is just relying on some individual to say, hey, you got a problem with your trail, to me, I just think we should have something in the system where staff is actually driving the trails, or
regular checkups.
There's some kind of a process that we could prove, right? Maybe you guys have already addressed that issue.
Yes, and that's a really big part of my role here in the county, and that's one of the reasons I was brought on to this Parks and Trails coordinator position was created, to have somebody out looking at this stuff, not relying on, not waiting for a problem to arise and then somebody to call. So the Parks Department, myself and Mark and our seasonal Zach, we're trying to be as proactive as we can, getting out, looking at this stuff every week. I feel like we have a really good relationship with all of our user groups. And I'm on the phone with the Friends of the Stour, Friends of the Gandy, Snowmobile Club, a couple times a week, talking about issues. So that network, that structure of, how to share information I'm really confident and feeling good about it.
But should that be in our plan that we do that? Is it in the plan?
It is in the plan.
It is in the plan. Okay.
Yep.
Gotcha. Thanks.
All right, anything further that you guys can think of regarding concerns on the trail? Do you feel like you've answered the questions, that we have what we need in the plan based on what we've heard today?
Mhm.
Okay. All right. So wanted to kind of give you an opportunity to talk about any changes that you might have heard based on the most recent public hearing information to these two choices. And as I mentioned at the beginning of this presentation, the DNR is going to be looking for not only what are our allowed uses on this trail, but why did we select those? And one of the main reasons we as staff are pushing for a rationale from you guys as supervisors is because it looks pretty close in terms of public input as to those 4 changes versus those that are for keeping it the same. So we wanted to get some more information on paper in the plan as to why you guys as supervisors felt that these 2 choices were the best choice amongst the alternatives that were presented to you by tool design. Does that make sense?
Sure.
Yeah, go for it. By all means.
I guess looking at the rationale that I'm saying is we have 3 trails. You got the Cattail and you got the Stour and you got the Gandy. And SA3 fits all 3 because then they would be the same.
Okay, so continuity between
Yeah.
all 3 rail trails?
That's basically it.
Makes sense. Any other?
One thing I would add is part of the history of this trail. You could go back to the original master plan.
Sure.
That's why we've been talking about it. That's why we're here today, because of what happened with the original, which wasn't in your history here, because it really started 10, 15 years ago or 10 years ago. I don't know.
Yeah, 2004.
But I think that should be one of the rationales of doing this, is that we're going kind of back to what the original intent of the county board and the public was when the trail, and we even heard from state representatives when it was funded, that's why that trail was developed, was for those uses.
Sure.
So to me, that kind of covers all of it. And again, to me, the fact that it's close tells me that means everyone wants to use it.
Yeah,
So that's how I slice that piece of bread.
Really demonstrated a lot of interest in
Yeah.
trail usage in the county. Anything else in terms of rationale as to why SA3 was chosen over the other 3 alternatives? I'll start with that, the snow wheel side of it. Besides connectivity, continuity, the original intent. Kind of stuff.
Yeah, and I agree with that economic development piece of it.
Yeah.
That was key, and we heard that multiple times.
Okay. All right. How about for equestrian uses and selecting EA2? Are these things kind of mirrored down there, or do we have additional rationale?
putting
You're
that out
just the
there.
worst guy, huh?
I'm not gonna comment.
Well, you put that, it wasn't an original use. But it was, there's a lot of interest in it. I mean, that group just kind of showed up and it is huge.
So level of interest,
The
sure.
level of interest again on
I'll just make the comment that I am for multi-use as much as we can, because you don't displace anybody if the person doesn't want to come, the other one's using it. I made that point before.
So as many users as possible for the having access to the trail. Okay, makes sense. Anything else you'd like to provide for rationale on these two choices versus the others? Just want to, like an auction, going once, going twice.
No.
Okay. Anything further you want to add, Ben? Okay, sounds good. Well, if you think of anything, get it to me as fast as you can, so we can include it going forward. We can recap this stuff, I believe, at the next meeting, just to make sure we've got everything on the 8th. Okay, thanks. Lastly, I just wanted to go through kind of the next steps going forward from today. So it's our recommendation that you guys, as the ESC, give us a directive to talk about developing a resolution for sending that to the county board and adopting this plan, as a recommendation. So we could have that to you for the next meeting on July 8th. And then with that resolution, we'll get that to you ahead of time so we can have both ourselves look at it, legal counsel look at it, and you guys look at it. And we can move that forward potentially at the next meeting on the 8th. Subsequent to that, it could be on the county board agenda on the 21st. Tool design, just like they presented for you guys here at the committee level, is invited back, and we're presenting a very similar presentation to what was done for you guys to the full county board. So everybody's on the same page, understands how we got to the point where we're at right now. And then at that plan, at that meeting, the county board will consider that a resolution for adopting the plan and sending it on to the DNR for their review. Any additional updates that come from either the 8th meeting or the 21st meeting in July, staff will make those changes to the plan and then send it to the DNR. DNR gets their time. I believe it's a 30-day window, but don't quote me on that. They gave us pretty quick feedback the last time when we submitted a plan. And they'll identify if there are any updates or changes that are needed to the plan in order for them to give their stamp of approval. And then we'll bring that information back to you, make those updates, and get this plan finalized. It's kind of a generic outline as to where we're going from today.
All right. Which is good. So for direction, so you just need a motion to keep our list in order and a resolution to move it on with SA3 and EA2 as our selection.
Chairman O'Connell, yes, we need a formal recommendation to direct staff to draft that resolution, that enabling resolution, which we'll bring to you at the next meeting, the July 8th meeting.
Okay.
And will be forwarded to the full county board. We'll need a sponsor for that resolution as well, but that's the next meeting's agenda.
Okay.
So for today, yeah, we just need a formal motion to recommend to staff to draft that resolution.
Oh, shit. Go ahead, Doug.
Is it time? I'll make that recommendation to direct staff to create a resolution to move this forward. Is that stated correctly?
I think so. Sounds good. Second?
I can second it.
Okay, Trace.
Chair, I won't be voting.
Okay. All those in favor then say aye. Aye. Opposed? Okay. All right. So that'll keep our schedule on track.
Mm-hmm.
All right. Good.
Thank you very much.
Who is part, you got part B, Ben? Okay.
Yes, I will cover B and C here. So update on the Parks and Trails Advisory Group. Those, the notice or I guess the notice or the posting that the county is accepting applications for that group went out. We're going to be accepting applications until the 17th, and then hopefully that'll give us a couple of weeks to go through that, and then maybe in August we'd have our first meeting. This is kind of the goal. So.
Okay. So that's moving good. So that's good. Have you got any yet or not? Or you just put it out?
Just I haven't received anything yet.
Okay. The dam update.
Update on the Atlas Dam. The municipal grant process concluded. We were not selected as one of the recipients of the grant. There were 32 or 33 applications filed. They funded 23 of them. We don't know why. That was the letter we got from the DNR that we weren't selected for priority funding. So next steps in that process, the DNR outlined a few repairs that need to be done to the dam, and they gave us some dates last year or in November with the letter of concurrence, 2021, 2022 for these repairs. We've spoken to the water management engineer from the DNR. He's flexible with those. He understands that we didn't get the grant. So he's going to be in contact in the coming weeks here and talk about setting those dates out further to allow us to apply for the grant for the next cycle, which is in 2 years.
Are the repairs major? Or were they, well, if we wait too long, will it be worse?
It's been in the shape it's in for a while. I'm certainly not an engineer. I have no idea.
Okay.
But if that's some information I can get for the next meeting, if you want to.
That would be good. Then if we wait, will something?
Sure.
Cost is double.
Chairman O'Connell, there's some exposed rebar on the abutments and some cosmetic issues. The letter of concurrence did ask us to repair those, but like Ben had mentioned, we talked to the DNR and they're flexible with those improvements or repairs, and encouraged us to apply in 2 years. So hopefully, any repairs will be nominal, if any, to be made, and then we can just go ahead and try next grant cycle to subsidize those costs.
Okay.
So in a nutshell, we're kind of punting this project down the road 2 years.
Sure. All right. Anybody else with any questions? Okay. We're done with parks.
All right, are you ready for me to start?
We're ready.
All right. So we did go ahead and we filed a petition to amend the ordinance for the CAFO conditional use provisions on June 16th. That notice has went into the paper. There's going to be a virtual hearing and that, very similar to like you've seen with the Stour plan, and that where people will be able to come in. They'll be able to record their comments. We also did this just to take an offer the people that are busy during the day or are going to be at work. And that on July 8th there, when you guys are having your meeting, to have another opportunity to provide comment. So on July 1st, and that virtual comment session will go from 2 o'clock to 8 o'clock. It'll be in the room here. And then on July 8th, and that you guys will also receive comments too in that though. So it'll be a little bit different than the other plan, where you guys didn't take any comment really in person, and at this time you couldn't have comment in person. So, so everything's set there. As part of that petition, we did notice in that the DNR and DAT you know, and that's just automatic. Not for the approval of those conditions, you know, and that, but they were noticed. So we might get comment or we might not. So that's basically all I've got for that.
Okay. That sounds good. Okay, you're gonna demonstrate then our zoning permit software.
Yeah, so effective the first of the year this year, we signed contracts and stuff last year. Basically went through a whole year of data migration into this new program. The program itself is called Ascent, and the company that put it out is called Transcendent Technologies. And there's several different permitting platforms out there. But we liked Transcendent, and that because they were the only ones that really allowed septic pumpers to be able to report sanitary maintenance and that online. In the past, it's evolved throughout the years, but basically we would be sending out postcards, and that the postcard would be signed by the pumper, and then either the pumper or the homeowner would mail those cards back into the county, and then Lori would enter them all manually into an access database. And so that was kind of the whole procedure. Lori did an awesome job in that, creating this access program basically from scratch, and that with Dave and that in IT. It worked really good, but it was very time consuming. And you can think, you know, like a holding tank that might get pumped every month, she'd have to take and manually enter a date, who pumped it, and any special notes for each one of them. So we've kept that information. It goes back to about 1984. But that information was also only in our office, so it was not available to the public. And that's one of the big things in that with this new software is that we can provide this information to the public, and that we're also using it for our scheduling of staff and that for our on-site visits, and we're also keeping track of whether a permit is pending or whether it was withdrawn, so we can keep track of status. So with that, we just want to give you guys kind of an update so that you know that this is out there, and then you guys can also go in and run your own reports and see how many permits we've issued in that throughout the year already, and that we're check on a property specifically if you want to look at one property. So we've got several links throughout the county website to be able to connect up to the software here. Basically, that underneath the Land Information Department, it says sanitary permit tracking, and then the Ascent Permit Management Suite. So yeah, go ahead. So this is the screen. We have various user types, and that as the access type here. Public is just what everybody can get into. There's no login for that. If you're a pumper and that, or a pouch maintainer, you have to have a login, as well as staff. And that, so we're able to get in and actually modify the files and that, whereas the public is only going to be able to get in and see the information. So just to start off with, let's say that I applied for a land use permit in Polk County, and that, can you just hit the status there, drop it down to pending, and then hit find now. So this here is basically all of our pending permits. Right now, you can see that we've got 72 pending permits. We have various land use permits and sanitary permits. It's all by name and by town here on when they come in. Drop down to 60. So here's just all of them, and that, and I had one had it set up for an example. You find 2020-486. Be up towards the top. Yep. So I threw a few comments in here just to kind of use it as a demo. This one here, you can see that it was applied for, or we received it in our office on 6/22. It's pending. We put in who's working on that application. So if it's myself or Liz or Rory, or if it's a subdivision plat, it might be Steve Geiger. The permit numbers there, shoreland and that's like what lake classification it is, or if it's in a floodplain area. The cost of the project, that we use that basically just to send it to the assessor so they have kind of an idea what that assessment should be. It includes our setback information. There's not any on this one because this is an address, but and that, so we can put in the setback from the water, setback from the property lines, the roads, and that activities. Go ahead and hit that. So as the public, I can look at it, say, oh, looks like Jason's assigned to go out there and do an on-site inspection, and it looks like he's going to be doing it on the 25th. And then we're able to, as staff, go in and actually print out an activity report, and that'll tell us all the sites that we're supposed to go to and that day, because Rory's the one that's actually putting in the actual activity date. And then once we get those activities done, we would go in and take and either approve the application or mark them as complete, or maybe we have to do a follow-up site visit after they restake it. You know, that kind of way is how we can track stuff. If maybe that permit had been out there for 2 months, hit notes there, and that we actually keep notes in here. And that as time permits and as we can keep it updated. So let's say that this was a new home permit, and that we could take and say waiting on sanitary paperwork in there, so that the public or the contractor could go in there and say, oh, that's why they're holding up my application. So, and then it has the date for that. Any questions so far?
Jason, can you talk about some of the efficiencies that this has created for both staff and our customers?
Correct. So there's a lot of scheduling, and that before, with 72 permits, people were wondering, where's my permit? What's the status of my permit? And then for, 2 or 3 of us in the office, we've got 72 permits to sort through. And that, whereas as long as we can keep this updated and that, it'll save us phone calls. And that, because we can have people going out here and seeing how their permit is progressing and that, and then also, and that just with those activities, it keeps us to be able to organize our day. And so when Rory puts the activity in there, she also marks it into our Outlook calendar, and she bookmarks out basically a time slot for that project to be done. So it's all about workflow and organizing the workflow, and then still trying to put that information out there where they don't have to wait for a call back from us. They can go out and take and see it online. So.
Good job.
Anyway. All right. Then let's just go back to permit search, Bob. Return to search. Right here. You just drop down here. Drop that down, yep. Permit search, yep. Okay, and then if you just change this back to all statuses. All statuses up at the top. And then for the actual general public, when they want to take and look up a property, and then let's say they want to look up their own property, or they have an address, if it's a real estate agent that wants to find out sanitary permit paperwork or sanitary information, you're able to search by any of those criteria right there. So I'll just give you a site address, Bob, if you can type in the site address. 2214 75th Street. So you'll see in that it kind of helps you in that by bringing up all the possible addresses in Polk County. I think it was, 75th Street. So here you can see, and that here's the actual permits that we have. We have a sewer and then there, and that which is by the SAN. That's how you tell that it's a sewer. And that the LUs, those are land use permits. And I will go ahead and open that up. Yep. So it tells you when it was issued on. Now, if it's a permit that we've actually put into the program, and that there's going to be a lot more information on it because we'll have the same fields. In the old program, we didn't have all those fields or all that information, so and that they're not going to be as complete as the newer files and that. So it was quite a mess. To give you an idea, we had around 16,000 in that sewers and that were converted over. There's roughly about 40,000 land use permits that were converted over. We had to go through and we had like 900 different types of dwellings in our old programs. We had to classify them, and that is how we wanted them classified in this program. So that's why it was basically a year-long project to get it converted. So, but here, you know, in that you're able to see the setbacks, the activities, and that, and so on. And that, so there's a permit issued. It's on the Big Lake, you know, contractor listed. So, yeah.
How do you look up the sewer? Like for if I got to replace a pump, can you go to the sewer one and does it show the?
Go ahead and go back. You just return to search results right up there. Okay, so if you just click on sanitary none. So, and that it shows you, and that now here we've got it in a bad date for report being issued, because this is prior to the county having any computer on file and that for the sewer system before. So anything that was not recorded in the computer before, and that automatically got signed a 1900 date, and that has to do with our maintenance reporting system and that, so that we can send out cards, and that. But if we do old Polk system, and that it would tell you like the sewer system, where it was installed, the installer, the design flow, you know, application rate, what they've got for tanks out there, the components, and that, so it's going to automatically trigger maintenance cards every 36 months or 3 years. And that if there was any reports done by a post maintainer, they would be automatically in there. But if we click on that parcel number too, this is kind of where it really interacts well with our GIS map. And so it automatically brings you right to that property, zooms you right in there automatically. And then let's say I want to see what that actual sewer document looks like, then you're able to click on that PDF. And here's the old sanitary paperwork. So throughout the whole COVID deal here this spring, and that Lori's been very busy and she's done an excellent job on back scanning and that all of our old files. And right now, and that everything north of Highway 8, every permit that's ever been issued in Polk County is online. And everything south of Highway 8 issued after January 1st, 2015 is also online. And then we're back scanning as time permits, and I think she's got 3 or 4 sections done south of Highway 8. So, but then here,
What was the
you'd be able to
cost
see
of
the
the
information.
Yeah, from 85. When we raised the prices,
I think you guys screwed up.
I think it says $1.
Up a little bit.
$1 for a tank. What was that permit? That's it.
I think maybe that one was scanned kind of blurry for a reason.
Yeah.
These are really old. These are the old carbon paper, you know, and that. So, but they do scan pretty decent. So, and a lot of them are relevant, you know, and this one here is the sewer that is still serving that property today, and it was installed in '75. So, I don't see it on there, Bob. So, so that's where all the other ones are, and then you'd be able to go back to your permitting link as well. Yep, those are all land use permits and that for that. So then I I can log in and that and show you, and that, but anybody and that in the public can take and submit a user request form to us and that with their password and their username that they want to use. And then they can take and go in and log in and they can run reports then. So let's say that you wanted to know how many land use permits has the zoning office issued this week, you know, that you can actually search by date and that, and you'd be able to pull up all the permits for this week, and that for that. So we're giving that information out to anybody and that wants to have a user to be able to log in. It was suggested to us by Transcendent not to just open that up to the public, because if you do, then there's no way to take and track where that information is coming from. And that, like if somebody was to go in there and pull a bunch of information, there's no way to tell if they actually got the information from here or where they got it. So by having a username, and that it could be traceable, and that to say that, yes, they came in and ran this report on X day, you know, so that's why we're doing it, and that, but it seems to be working good. I think we've got roughly about 40 users right now, and that with actual logging. So, yeah, yep. Tracy's one of them. So that's kind of just a really rough rundown of how we've been using the actual new software. Is there any other questions?
No, looks good.
Well, one of the things, you know, and that as staff, you know, Lori has made it pretty clear that she's not going to be around forever, you know, and because she was the one that really created the access database, and that she had 72 different tables of data, and all those different tables and that were all linked to actual queries to be able to do searches like this here automatically does for everybody. I mean, this is something that I can do. I'm not a software developer like she might be able to. So we wanted to be able to get our information and have her help facilitate the transfer into this new software, so that we had somebody that really knew what they were doing and what the information was to make sure that we got it transferred over as best as possible. So that was really nice to be able to get it done when Lori was here. So.
Okay.
Right.
Any questions? Well, thank you.
Yep.
Number 10. Annual reports, do we get those here?
Do you want to?
No?
Yes, I can address that, Mr. Chair. The annual reports, which normally happen in June, and I think on your work schedule, that's when it is. With COVID, with the audit and everything, it's been pushed back. It's going to be July before we get the final numbers from the audit, and we'll be able to present the annual report then.
Okay. Probably the second meeting then?
I would think so.
The second meeting would be better to put it on. Okay. Okay, number 11 then, what we gotta,
Chairman?
yes,
Yeah, just to start the conversation, 7A will be on the agenda for July 8th. Yeah, it'll be, oh, excuse me, got the wrong one. 8A.
there we go.
Right, that will be the resolution for you all to consider regarding the Stour Seven Lakes master plan. So we'll work on that immediately for your consideration. I would like to suggest another update about the Parks and Trail Advisory Group. Ben might have a little bit more of a sense of how the applications are coming in.
Sure.
By the way, the advertisement is in the paper and will be in the next week's paper as well. He also sent it out to his network of stakeholders, so we're hopeful we're going to have a good response to that that group. Another suggestion would be, well, this is in our notice. There'll be the public hearing for both the swine CAFO. There's a subdivision review as well as the signature authority, that housekeeping piece. Yeah, so that is the actual official public hearing date. However, by the 8th, we will have compiled all the video testimony from the July 1st virtual public hearing that we'd have scheduled. And again, in the same format that we use for the Stour Trail. Again, like Jason mentioned, it's between 2 p.m. and 8 p.m. to allow folks that have day jobs to come and give video testimony. So what we'll do is we'll compile it all, probably show it first, and then open it up for the in-person public hearing on the 8th.
Okay.
Does that make sense?
Yep.
So that will be on the 8th as well. And I suppose what's been stricken there, 9B, we could put on there if there's an interest to discuss what you've heard from the public hearings. If we've learned some more information from Health and Human Services perspective, and what we've learned from, the WCA attorney today, if there's an opportunity to talk about that, I could put that on the agenda.
We should have it so we can discuss it.
Okay, we'll do that. That makes sense? Okay. And then I have a suggestion. I know, it's nice to be able to learn about some of the things we do behind the scenes, even some of our core function stuff. Colton and Eric Wojcik just finished their annual transient ag survey. They do that every year. There's these data points throughout the whole county where they measure soil erosion and look at agricultural production. It's very informative, and so they'd be willing to give a brief presentation on that if you're interested. It talks about emerging trends in agriculture and what the soil conditions are, and the switch from hay ground to row crops. If you're interested, it's not a long presentation, but I could offer that up for you all as well.
Okay. All right. Anyone have anything else that they think of? Hopefully tie this one down so we don't amend it every day. It's tough, isn't it? Yeah. Every time I call you, we just did it. So.
I do have one more to add,
Okay.
Chair, and that not for your next meeting, but the second meeting, which would be July 26th. And that we do have a rezone public hearing, and that we've had it for quite a while. And if you're okay with it, I could take and send out the actual notice and that for that hearing and make that day. So,
Yeah, we should have, yeah.
okay, sounds good. We'll do.
Okay. Any other? All right. You're number 12. Yep. God, all in favor, say aye. You got the chair. He's kind of
That's
waiting.
the last one. There you go, John. I did my job for you.